Recently, the Supreme Court of India took significant steps to address the issue of child marriage with some powerful guidelines. A bench comprising Chief Justice of India D.Y. Chandrachud, Justice D.B. Pardiwala and Justice Manoj Mishra issued a set of guidelines to prioritize prevention before protection and protection before penalization. Hello everyone, I'm your host Shambhavi and you're watching Life Law. Today we are diving into an important issue that continues to affect millions of young lives in India: child marriage. Despite a long-standing legal ban, child marriages remain a harsh reality, especially in rural areas. The Supreme Court recently made headlines by issuing guidelines that emphasize prevention over prosecution, stating that prosecution alone isn't enough to bring lasting social change. In this video, we'll discuss these guidelines, the legal framework around child marriage, and the path forward that India's highest court has laid out. Let's get started. First off, what exactly is a child marriage? Simply put, it's when children are married before they reach the legal age of marriage, which is 18 for girls and 21 for boys in India. Before we delve into the Supreme Court's recent decision, let's look at the big picture. India has one of the highest rates of child marriage in the world. This isn't just a social issue, it's a legal one too, with severe consequences on education, health, and the empowerment of women and girls. Let's look at some eye-opening statistics. According to the National Family Health Survey, around 23% of women aged 20 to 24 were married before the age of 18. That's millions of girls whose childhoods are taken away from them. Early marriages can lead to a lack of education, increased health risk during childbirth, and even domestic violence. It's a significant barrier to gender equality and development. The numbers are staggering. According to UNICEF, around 223 million girls in India were married before they turned 18. The legal framework exists, but what's missing is enforcement and community awareness. The Supreme Court is now calling for a focus on prevention through guidelines aimed at creating an impact beyond mere legal prohibitions. India's primary law against child marriage is the Prohibition of Child Marriage Act, PCMA of 2006. Under the PCMA, child marriage is considered illegal but not automatically void, which is a crucial distinction. While the law prohibits marriage under the age of 18 for girls and 21 for boys, it allows such marriages to be considered voidable at the option of the minor involved. This means that if either party, upon reaching the age of majority, wants to annul the marriage, they have the legal right to do so. Let's understand some important sections of the Act include Section 3. This allows child marriages to be declared void at the minor's discretion. Section 9 penalizes an adult male marrying a girl under 18 with imprisonment of up to 2 years. Section 11 penalizes parents or guardians who knowingly arrange a child marriage, also carrying a potential 2-year prison sentence. All magistrates are vested with the authority under Section 13 of the Prohibition of Child Marriage Act 2006 are directed to take proactive measures, including issuing suo motu injunctions to prevent the solemnization of child marriages. But as we'll see, the Supreme Court argues that the law alone isn't enough. Without preventive measures, these provisions aren't making the change they aim to. The recent Supreme Court ruling highlights that while prosecution can deter, prevention is the key to eradicating child marriage. In a set of guidelines, the court emphasized that preventive efforts should take precedence and should be multifaceted. Let's break down these guidelines. The first guideline emphasizes that any marriage involving a child must be registered immediately. This is crucial because it helps authorities keep track of such marriages and enables them to take prompt action. The registration should include details about both parties and their guardians. By making it mandatory, the courts aim to create a transparent system to prevent illegal child marriages. The court has directed that educational institutions must spread awareness about the harms of child marriage. Schools should include specific modules in the curriculum that educate young girls about their rights and the negative impacts of early marriage. This aims to equip them with the knowledge to resist societal pressures. Educational institutions play a pivotal role. They are now required to report any instances of child marriages. If a school identifies that a student is married under the legal age, they must inform local authorities immediately. This initiative not only protects the child but also promotes the idea that education should be prioritized over early marriages. Now, schools can serve as a vital link in the community to raise awareness and educate parents about the importance of keeping children in school. Teachers can encourage dialogue around the harmful effects of child marriages and support students in navigating these challenging situations. All states and union territories are instructed to include comprehensive sexuality education in school curriculum, following guidelines from the World Health Organization. This education will cover legal aspects of child marriage, gender equality, and reproductive health rights, and how child marriage affects the physical and mental health. The content should be age appropriate and culturally sensitive, focusing on empowering students to know their rights, the importance of delaying marriage, and understanding sexual and reproductive health. The Supreme Court strongly encouraged the need for awareness at the grassroots level, especially in rural areas. Governments and NGOs are tasked with organizing outreach programs. These programs would involve community leaders, educators, and parents to help change societal attitudes towards child marriage. This initiative aims to create child marriage-free villages. Panchayats, that is, local governing bodies, and community leaders will take an active role in stopping child marriages by preventing them and reporting any cases. Through this initiative, communities will work together to discourage child marriages, with panchayats monitoring and promoting child marriage-free certificates for villages. Villages that earn this certification will be recognized publicly, celebrating a culture where children's rights and well-being are valued and protected. So comprehensive awareness of helpline numbers such as Childline, that is 1098, and Women Helpline 181 should be included in all educational materials and community campaigns. Healthcare providers, including doctors and counselors, will be trained to address the specific health risks associated with child marriage. The Supreme Court has also issued directions to empower local authorities such as Child Marriage Prohibition Officers, CMPO, and Panchayat officials by granting them more authority and responsibility in preventing child marriages. This includes regular inspections, community surveillance, and follow-ups to ensure no illegal marriages are taking place. The guidelines call for improved enforcement of existing laws that prohibit child marriage. Local authorities, including police and child welfare committees, must be proactive in preventing such marriages. This means conducting regular inspections, raising awareness in communities, and ensuring that legal action is taken against those who facilitate child marriages. So, to enable personal accountability and ensure that immediate preventive measures are taken against any planned solemnization of child marriages, each state and union territory is directed to upload quarterly reports from CMPOs on their official websites. These reports should detail the steps taken to prevent child marriages and the outcomes of investigations. The Ministry of Women and Child Development and Ministry of Home in each state UT shall conduct quarterly performance reviews of CMPOs and law enforcement agencies. The Ministry of Women and Child Development is directed to execute mandatory training refreshers for CMPOs every 6 months. The collectors and superintendents of police in each district across India shall also be responsible for actively preventing child marriages within their districts. They shall have the authority and responsibility to prosecute all individuals who facilitate or solemnize child marriages, including those who knowingly assist, promote, or bless such marriages, even if reported in public events or media. The court also emphasized the importance of support structures. Children in vulnerable situations should have access to counseling services, legal aid, and rehabilitation. The focus is on creating a safety net for minors to report cases and seek help without fear of retaliation. The Ministry of Women and Child Development is encouraged to create educational support programs for girls at risk of child marriage, including scholarships for secondary and higher education to help families prioritize education over early marriage, stipends or financial support for families with daughters who stay in school past age 15, encouraging them to delay marriage. Mentorship programs to connect at-risk girls with role models who have achieved success through education and careers. The Ministry of Women and Child Development will also explore social welfare programs to support families at risk of child marriage, including conditional cash transfers that give financial help to families who commit to keeping their daughters in school and delaying marriage until adulthood. Vocational training and skill development programs for families to improve their income, reducing the need to marry off daughters for financial support. Support services for families facing financial hardships such as food aid, healthcare, and microfinance options to help them achieve stable livelihoods. The National Legal Services Authority, NALSA, will create a standard operating procedure that offers clear guidelines for legal support and long-term rehabilitation of child marriage victims. This SOP will help lawyers and law enforcement officers prevent, protect, and support these victims. NALSA will send this SOP to all state and district legal services authorities to assist those affected by child marriage. Recognizing the sensitivity and unique aspects of child marriage cases, a specialized police unit is deemed essential. The State Ministers of Home Affairs shall consider the viability of integrating the Special Juvenile Police Unit into the child marriage prevention framework. The state government and UTs shall constitute a state special child marriage prohibition unit where there are more than one CMPOs in any district, a district level special child marriage prohibition unit. The unit shall comprise of all the CMPOs of the state or the district, as the case may be, and shall include 5 social workers having experience of working against child marriage or on child rights, and at least 2 of such social workers shall be women. The union government, in coordination with state governments, is directed to assess the feasibility of establishing special fast-track courts exclusively to handle cases under the PCMA. These courts will expedite case proceedings, thereby preventing prolonged delays that often lead to additional harm for the affected children. The Ministry of Home Affairs, along with the Ministry of Women and Child Development and NALSA, will set up an online portal for reporting child marriages. This portal will allow anonymous reporting, making it easy for victims and concerned citizens to file complaints and access support. The portal will also collect data on child marriage cases, helping authorities take targeted actions. It will improve accessibility, transparency, and accountability by ensuring all reports are quickly addressed by enforcement agencies and CMPOs. Lastly, the guidelines emphasize the need to promote government schemes aimed at improving the lives of children. This includes providing financial assistance for education and healthcare, as already discussed, ensuring that families do not feel pressured to marry off their children due to economic hardships. For example, initiatives like Beti Bachao, Beti Padhao aim to empower girls and promote their education. Access to educational and financial support can significantly reduce the likelihood of child marriages. Coming to the Supreme Court's observations on child betrothals. The Supreme Court has suggested that Parliament amend the Prevention of Child Marriage Act 2006 to explicitly ban child betrothals. Since child betrothal is not currently addressed under the PCMA, the court noted that it could be a loophole to avoid penalties under the Act. The court stated that betrothing children takes away their freedom and choice in selecting a life partner and disrupts their childhood. It also referenced international treaties such as the Convention on the Elimination of All Forms of Discrimination Against Women, which oppose child betrothal. In a judgment led by Chief Justice D.Y. Chandrachud, the court highlighted the need for spreading community awareness instead of solely focusing on prosecution. The ruling stressed a community-driven approach to prevent child marriages, noting that legal actions should consider the impact on families and communities. In several rulings, the court has underscored the importance of protecting children's rights and emphasized that betrothal, even as a traditional custom, should not lead to child marriages. The Supreme Court has also highlighted that early engagement often contributes to societal pressure to proceed with marriage as soon as the engaged children reach puberty, which can conflict with the principles of free consent and well-informed decision-making. The court has emphasized the importance of nurturing a culture that prioritizes the autonomy and health of young individuals, recognizing that early engagement can limit future choices and lead to other complications like early pregnancies, which affect both maternal and child health. Let's discuss certain key cases and laws where these principles have been upheld. In this landmark case, the Supreme Court held that sexual intercourse with a minor wife under 18 years is considered rape, closing a legal loophole that permitted marital relations with girls aged 15 to 18 if they were married. This judgment reinforced the stance that children, including young girls, should not be subjected to marriage, betrothal, or any form of engagement that could infringe upon their autonomy and right to childhood. Prohibition of Child Marriage Act 2006, as already discussed, the Supreme Court has often referenced the provisions of this act, which criminalizes child marriage and provides legal grounds for the nullification of marriages involving minors. The act underscores that both betrothal and marriage should involve individuals of legally consenting age, that is 18 for women and 21 for men, supporting the court's emphasis on protecting minors from societal pressure that lead to early marriages. Though this case primarily addressed child marriage, the Delhi High Court, often cited in Supreme Court discussions on child rights, observed that cultural practices like early betrothal can contribute to child marriages, which contradicts the intent of Indian child protection laws. So, why hasn't child marriage been eradicated despite all these laws? The court acknowledged several challenges. Social norms, economic factors, and lack of education perpetuate the cycle of child marriage, especially in underdeveloped areas. This is where the preventive approach is crucial. So we need to understand that laws need the support of society to be effective. The Supreme Court's guidelines focus on societal transformation, urging parents, communities, and religious leaders to shift their mindsets about marriage age and recognize the benefits of delaying marriage. One recommendation was to provide economic incentives to families for keeping their daughters in school and avoiding early marriages. Programs like Beti Bachao, Beti Padhao have proven that financial support can motivate families to invest in their daughters' futures. The guidelines also call for regular reporting and monitoring of local authorities responsible for preventing child marriages. States are urged to hold these officials accountable, ensuring that they remain active in their roles. The Supreme Court's guidelines mark a vital step toward a future free from child marriage. The focus on prevention rather than prosecution alone underscores a deeper understanding of how laws need to be supported by education, awareness, and local accountability to make a real difference. However, these guidelines need us, the citizens, to actively participate and spread awareness. Every individual, community leader, and educator has a role to play in ensuring that children are free to live their childhood without the shadow of early marriage. Imagine a future where children can dream big, go to school, and pursue their passions without the burden of early marriage. That's the kind of future we want, and together we can make it happen. Don't forget to like, subscribe, and share this video to help us spread the word on this crucial issue. Let's work together to protect the rights and futures of children. Also, hit that subscribe button and turn on notifications so you don't miss out on any of our future videos. Let's keep the conversation going in the comments. Share your thoughts on this important issue. What do you think are the most effective ways to combat child marriage? Thank you for watching, and I'll see you next time.